Mr. Hibner, and welcome, counsel. We're pleased to have you with Judge Bennett and Judge McClarity and me for your oral argument today. Please understand we will conduct the hearing in the same manner as if all of us were together in the Supreme Court room. The appellant has 15 minutes and the appellee has 15 minutes. And of course, that time must be shared if more than one wishes to argue. And of course, the appellant may reserve up to 5 minutes, and I believe that amount of time has already been scheduled. Will more than one of you be arguing for the appellant and appellee?
Only one for the appellant, Your Honor.
Your Honor, I will argue 10 minutes for the appellee. Ms. Miller will argue 5 minutes, if it pleases the court.
Thank you, all three of you, for working that out ahead of time. All right, unless there are any announcements, we'll ask Mr. Hibner to call the case.
William L. Kellerman et al. Versus Gerald S. Gabriel et al.
All right, proceed.
Thank you, Your Honor. May it please the court, my name is Jerry Farmer. I represent the appellant, Gerald Gabriel, in this case, and as I've asked Mr. Hibner, I'd like to reserve 5 minutes of my time for rebuttal.
Very good, 5 minutes, thank you.
Now, Your Honor, this case involves the question of whether the proper circumstances exist for parties who are adjoining landowners to have a valid and binding oral boundary agreement between them. This court last addressed this question in the case of Jack versus Dillahay, which has been cited and discussed at length in the briefs. In that case, this court discussed two inquiries which are essential in making this determination. First, the inquiry is, are there factors present that would justify the making of an oral boundary agreement? Those factors are two in number. There must be either a dispute or uncertainty about the boundary, and number two, there must be an intention to resolve it. In other words, the purpose of the agreement must be to resolve the dispute or the intention. And in fact, when you move to the second inquiry, it's a four-part inquiry, and the parts of that inquiry include on the second part of that inquiry, is there an agreement? The agreement must be made with reference to that dispute or that uncertainty. So it must be made clear by the terms of the agreement that the purpose of the agreement is to resolve a dispute or uncertainty. In this case, that the agreement that is alleged to have been made doesn't meet either one of those tests. Now, to tell the story of this case, we have to go back 40 years to the division of a parcel of land that was called by deed originally 35 acres. Now, I've depicted that parcel on page 38 of my brief, where I've shown the court the 1979 tax map. We're looking at parcel 9 on that tax map. By deed, it's 35 acres. However, as testified to by the tax assessor, there was a calculation made of the actual acreage on that parcel, and it calculated out to 40.5 acres. Now, one of the things the trial court got wrong was the very first conveyance that split this parcel. The trial court indicated that the very first conveyance that got made was to Mr. Farrell, who owned the western half of it. However, the evidence at trial that was adduced showed that the first conveyance was made in 1979, the date on this tax map, and it was made to by Kenneth Gasaway to Albert Gasaway. Now, that's what split this parcel, but there were also 3 conveyances before that conveyance got made. Each of those 3 was 1 acre. So you take the 35 by deed, you subtract the 3 1-acre conveyances that are in the record on Exhibit 29 at tabs 1 and 4, you're left with 32 acres. Now, the appellant contends that these constitute very important surrounding circumstances as to determining the grantor's intention when the grantor made this first deed to Albert Gassaway of 16 acres out of that 32-acre parcel. That split the parcel in half, and it gave the eastern half to Albert Gassaway. Later in 1983, the western half was conveyed to Mr. Farrell. Albert lost his in foreclosure. It got reconveyed to Mr. Horn. Mr. Horn and Mr. Farrell were neighbors. And it's the agreement, alleged agreement between Mr. Farrell and Mr. Horn that's at issue in this case. Now, when we got into the dispute with the Kellermans, we took Mr. Farrell's deposition after finding the common source deed. And he admitted that he couldn't own anything that Albert Gassaway owned. That was the Spring Branch double oak maple tree line that used the natural monuments as markers. So he said, but I moved that my eastern boundary a little farther to the east. And I said, well, why would Mr. Horn give you some of his property? He said, oh, well, I made a trade and I gave him more than he gave me. So according to Mr. Farrell, Mr. Horn came to him and said, I sure would like to log some of that acreage in the back. And Mr. Farrell said, oh, well, you know what? Road frontage is more valuable to me. So let's have a trade. And that's what allegedly they did. They swapped acreage in the back for road frontage in the front. And ultimately, Mr. Horn sold off. Ultimately, Mr. Farrell sold the part that adjoined that to the Kellermans. And the parties went on for a few years, and we wind up with Mr. Gabriel and the Kellermans as adjoiners. So Mr. Gabriel noticed the Kellermans encroaching further and further onto him and said, hey, wait a minute, you know, what's going on here? So I don't think anybody understood at the time. So the Kellermans filed a suit against Mr. Gabriel, and they had a survey, Exhibit 8. Mr. Gabriel went and got his survey, Exhibit 7. We took Mr. Farrell's deposition, and that's when we first found out about this alleged agreement, and that's when Mr. Farrell told us about the maple tree. So as Mr. Roberts described in his testimony at trial, when he made his first survey, he found the spring branch, and he defined spring branch as a point at which two streams flowing from springs intersect, which gives you a specific point from which to begin a legal description and run north from there. He found that spring branch. He found a huge double oak, which he depicted on Exhibit 7, his first survey, but he could not find a maple that lined up with it. When we took Mr. Farrell's deposition, he admitted, well, it's the big maple up at the corner of the house. And Mr. Roberts went back and took a second look and said, aha, now this all lines up. The pieces of the puzzle have fallen into place. And so he produced Roberts survey number 2, which is Exhibit 10 to the case. And that is the line that Kenneth Gassaway established the first time he divided that parcel in half. So we brought in Mr. Farrell. We thought the Kellermans might bring in Mr. Farrell and say, hey, if you, Mr. Farrell, conveyed to us property that actually belonged to Mr. Horn and was not your property to convey, then we need to look to you for a remedy, but that's not what happened. And so when we brought Mr. Farrell in as a third party, we noticed also in the survey that Mr. Roberts made, there was a barbed wire fence remnant in the southwest corner in the disputed part of the property. And we looked at the Faust case and said, it looks like we may have evidence here that piece, the part that was in dispute, was adversely possessed. And the only way we can resolve this completely is by having Mr. Farrell be a part of the case, because that was the holding in the Faust case. If a deed is champertus and void, you can't resolve a dispute between that the Champertus deeds grantee because they're not the owners. The property reverts in ownership back to the grantor of the Champertus deed. So we had to get all of the parties into the case in order to get a complete resolution. Now, the trial court overlooked the initial division of the property, and the trial court misread the Jack versus Dillahay case and all of its precedents, which say that if adjoining landowners can avoid the statute of frauds, then the purpose of their agreement must be to resolve a dispute or to resolve an uncertainty. And that's not what happened in this case. In this case, the parties got together and said, let's trade parcels. I'll give you this timber, you give me the road frontage. And the progeny of the Jack case say if two landowners get together to do that, then they have to get a survey. They have to clearly identify for the benefit of their successors the parcels they're exchanging and document that under the statute of frauds so it can avoid disputes like this one. So we'll ask the court to either establish the boundary as shown in the Roberts II survey or avoid the alleged agreement between Mr. Farrell and Mr. Horn and remand the case back to the trial court for a resolution of a boundary dispute between the Kellermans and Mr. Gabriel. I reserve my time for rebuttal. Thank you.
Thank you, Mr. Farmer. We'll now hear from the appellees.
May it please the court, Chief Judge, Your Honors. My name is Matthew Cowan, and I'll be arguing on behalf of the appellees Kellerman. We respectfully reserve 5 minutes for Ms. Miller. Your Honors, if I might just touch briefly on a few things the appellant has raised today. We've not heard anything about what the trial court did in this case, and we haven't really fleshed out the factors of the Jack v. Dillahay case. Those 4 factors, just simply put, are number 1, was there an uncertainty or dispute? Number 2, did the parties or their predecessors in title come to a resolution or agreement? Number 3, was that agreement definite and certain? And then number 4, did the parties or their predecessors possess up to the agreed upon line or at least acquiesce in that line? Now, the one thing that the appellant did not raise, and that I think was crucial to the understanding of the first tenet of the Jack case test, is what Mr. Farrell testified to at trial. Mr. Farrell, at his deposition, let me back up, Mr. Farrell was not asked the question at his deposition, were you uncertain? And of course, we didn't have the testimony of Mr. Horn. He was deceased at the time of this litigation, but he was not asked the question, were you uncertain? He was asked the question, were you uncertain at trial? And Mr. Farrell testified he did not know the exact original line in this case. In fact, he said, quote, the line was doomed. And he went on to say, I don't think, by clarifying, by say, I don't think any of us knew where the exact original line was in this case. And from that, flowing from that, Mr. Farrell, testified that Mr. Horn placed fence posts in the ground, that he, being Mr. Farrell, said that's good. Mr. Farrell then drove a metal stake in line with these posts. And from that flowed the oral boundary agreement in 1992. So beyond that, there was testimony, much testimony, Your Honors, that this agreed upon boundary was in fact definite and certain. We heard actually from one of the appellant's predecessors in title, David Gilley, who testified, yes, I believe that the agreed upon line was the boundary in this case. I treated it as such. I was an owner for 10 years of that property. And then, of course, to the 4th prong of that test, Mr. Gilley testified and others testified that the parties used up to that agreed upon line. In fact, Diana Kellerman testified to that fact as well. So Mr. Farrell's testimony in this case is unrefuted, that the agreed upon boundary was in fact created, it was definite and certain, and that the parties possessed up to that line. And I believe that's why the trial court made the findings that it did. But as to the second point in this case, Your Honor, I don't know that the appellant spoke much of adverse possession, but the trial court looked at 5 different kinds of adverse possession in this case and dismissed all 5. And if I could just briefly touch on those TCA 282101 is talking about land grants from the state of Tennessee or North Carolina. Obviously, that didn't have any bearing on this case. Number two, the appellant looked at 282105, 7 years adverse possession, 30 years color of title. The trial court, again, with that and as well as common law adverse possession, the trial court said that because the Kellermans and their predecessors were in possession up to the line, and there was much corroborating testimony to that effect, that in fact the appellant did not claim adverse possession. And looking at the remnant fence, I believe that the appellant referenced, and quoting the Faust case, I think the difference in the Faust case here, Your Honor, is that in the Faust case, that of course the court was looking at an interlock in Clarksville. And in part of that interlock, the fence enclosed. In fact, beyond the enclosure, the parties there had gravelled the lot. They had rented it out to the Clarksville Police Department. They had stored equipment there. There was much evidence that they had possessed that. So this court found that with color of title was constructive possession. Here, the difference in this case is, as the trial court found, the remnant fence, as it was called at trial, just ran for a short distance south to north. It did not enclose. It was at a hilly southern end of the property. It was not on either claimed property line, and there was no evidence of who placed the fence there, why it was there, or that it had any kind of probative value as to adverse possession. So I think that there was also testimony as to an old farm road that was on the property. Again, the trial court said there's no testimony as to who created that road. It was probably there during the parent tract many years ago. And if the appellant were to rely on the old road for adverse possession purposes, in fact, that would cut off much of his property on the east side, the undisputed side. So the appellant testified at trial that he didn't know anything about these properties until he moved to Tennessee in 2012. He certainly didn't know anything about the oral boundary agreement, about what Mr. Horn said, what Mr. Horn did. And then looking just briefly, Your Honors, if I could touch on the issue of champerty, again, that flows through the Faust case as well. Here, Your Honors, the appellant would have to have shown that at the time Mr. Farrell made the conveyance to the Kellermans, to my clients, that Mr. Horn, the predecessor of the appellant, would have to have been in adverse possession. And Your Honor, there was no testimony to that effect. There was no testimony at all. In fact, the acreage claimed by the appellant just seemed to keep growing until the point of trial. At one point, it was 15 acres. At the point of trial, it was 17.7 acres. And there was no testimony or evidence that the appellant or his predecessors ever possessed the area that was in dispute. The only one who knew about this, really, as far as the usage of the property, was Thomas Mears. He was a farmer who cut hay on both sides. And the trial court said both parties used Mr. Mears to cut the hay. There wasn't a great enough yield of hay to make money, so both sides just used the same farmer. But that didn't mean that either side had possessed the other. They used the same farmer to cut the hay. And that was, Mr. Mears testified as to why there wasn't fence placed on the agreed upon line. He said that made it easier to traverse both properties for the cutting of hay. So for those reasons, Your Honor, there was no adverse possession shown in this case. And in my remaining time, going back for a moment to the oral boundary agreement, essentially what the appellant is asking this court to do is create a new test, to superimpose a new test on the Jack case, to say, Your Honor, is essentially, okay, under the second tenet of the Jack case test, the parties have to come to an agreement. They can't have any shred of idea of where the original boundary might be. But then, Your Honors, you can't come to an agreement, is what the appellant's saying, which completely vitiates the second tenet of the Jack test. So you've got to come to an agreement, but if you come to an agreement, that means you must have known exactly where the original property line was. And respectfully, Your Honors, that just was not what happened in this case. There was no testimony to refute Jesse Farrell, who testified that, in fact, he was uncertain. He didn't think anyone knew where the original line was at the time the agreement was made. And the parties used and possessed that line up until 2017, when the appellant began to write the appellee's demand letters. So, Your Honors, for those reasons, the appellees would respectfully request this court to affirm the trial court on all accounts, and I thank you for your time.
Mr. Cowan, before you stop, did I understand you to say that Mr. Mears, who cut hay for both of the neighbors, he relied upon the fence line to determine to whom to take the hay?
That's correct, Your Honor. He testified that his understanding was that the posts that were placed on the agreed upon line were the dividing line. Obviously, he went back and forth across both parcels, and the appellant admitted in his discovery that he removed those posts. So, yeah, they weren't there at the time of litigation, but the appellant admitted to removing those. So I think that was highly probative for the trial court in finding what it did.
All right. Thank you, Mr. Cowan. Ms. Miller, it's the floor is yours.
Your Honor, I represent the Pearls, and they were brought in on the third-party complaint, and they alleged champerty deeds as well as adverse possession. And my clients in 1992, actually the Pearls purchased the property from Kenneth Gasaway as part of 16 acres more or less by estimation, and that transaction took place in 1983. And so at the time also that Mr. Gasaway received back the property that was foreclosed on from his son, Albert Gasaway, I think that took place just a few months later. So Mr. Horn purchased that property. So Mr. Pearl and Mr. Horn owned that property. And in 1992, they came to the agreement. They did not know where the original line was. The only evidence that was put before the court was the testimony of Mr. Pearl, my client, and he testified that he did not know. The terrain is wooded. You cannot see any 2 points other than we do know that there is a spring branch that runs the entire length of both of these properties. But as these properties have never been surveyed, so they did not know, either party did not know the exact location. I know there's been, and Mr. Pearl did testify to that. So the oral agreement was made to establish the line. The posts were put in prior to Mr. Pearl selling this property in February of 1993. They were there. Ms. Kellerman testified that she, along with Mr. Pearl and Mr. Horn, walked that line. The posts were on that line. And in addition to that, we had Mr. Mears testify that he witnessed my client drive the steel post at the edge of the woods located on the agreed upon line. And the agreed upon line was in place for approximately 26 years before there ever was a dispute to the line itself. So all of the parties from the time that the agreed upon the agreement was made up until the lawsuit was filed were in agreement that those where those posts were located was the actual agreed upon line between the adjacent property owners that was established back in 1992. As to the champer's deed, we put on my client testified that he cultivated and farmed this land until the date he sold it. His brother-in-law and Thomas Mears, they used the barn that was on the disputed property. They used that without any dispute with Mr. Gasaway when he owned it, with Mr. Horn when he owned it, with Miss Boone or the immediate predecessor entitled to Gabriel. They turned and sowed down the field, the hay field, during the time on this disputed land, and there was never no dispute at all between these parties until, of course, the lawsuit was filed, until Mr. Gabriel removed the post and sprayed weed killer over onto the eastern side of the tract that is owned by the Kellermans. So as to the champer's deed, those posts were already in place. That land was already in the possession of Mr. Pearl before that transaction was done. So they cannot prove, and the witnesses that they brought in only had knowledge back until the year of 1997 and coming forward. And this transaction took place in 1992 prior to the transfer, which was made in February of 1993. So they cannot prove that they had even constructive possession or actual possession of any portion of that property that was deeded to the Kellermans, because that transaction, that land was already in the possession of my client prior to. In fact, the posts were there on the date that the deed was written, and the new property owners walked that line. So that line that agreement not only was established prior to the transfer, but it was also memorialized by posts going up onto that agreed line and have remained there for approximately 26 years before they were taken down. Thank you, Your Honor.
Thank you, Ms. Miller. We'll now hear from Mr. Farmer for a rebuttal. You're to unmute.
Thank you, Judge Clement. And is the court able to hear me clearly now?
Yes, sir.
Thank you. And Judge Clement I would like to address the question you asked of Mr. Cowan about what was done with the hay that was cut off the field that spanned across this alleged agreed boundary line. And I understood Mr. Cowan's argument to say that the hay wasn't worth enough to divide in between the two property owners. Rather, both property owners agreed that Mr. Mears was allowed to keep all the hay he cut off of both properties without accounting to either property owner for the hay. And I believe the record is pretty clear that that's the way it was. Nobody thought that hay was worth enough to merit dividing it up. So basically,
he did not need the fence line to determine who gets the hay because he kept the hay.
That's correct, Judge Clement. Nobody needed that fence line to figure out whose hay was whose. He kept it all, and that was his compensation just for mowing that common area. And
Yeah.
Which makes more sense when you think about, if you've got a big hay field and they're saying that the reason that no fence was put up, which, is one reason we say the second part of the Jack versus Dillahay test was not met. There was no definite boundary agreement. The conveyance from Farrell to Kellerman mentioned a partnership wire fence, which never was built, never existed. Why would you reference a fence line over a commonly mowed hayfield? So that just doesn't make sense. And then the other part of Mr. Farrell's testimony, his posture in this case is under the Champerty claim, okay? So if we were to void his deed to the Kellermans, then we would be in a boundary dispute with Mr. Farrell. If his deed is not void, then the Kellermans own the property and we are in a boundary dispute with the Kellermans. So I think Mr. Farrell's testimony goes two ways, and he tried to have it two ways. At his deposition, he said, I know where my boundary was. It went from this maple down through a double oak to the spring. And he drew a line indicating north to show that that's how it lined up, which is consistent with the parent deed. All right, so now if we were in a boundary dispute, he would be claiming, oh, well, now that survey that Mr. Moore did for me, I'm really sure that's where the line was, because if I'm in a boundary dispute, I need to know where my line is, and that's where my line was. He would be certain in his testimony, we argue, if we were in that posture with him. When you're in the posture of him being, he will be just a witness in a boundary dispute with the Kellermans. He wouldn't be a party in that case unless the Kellermans were to bring him in as a third party defendant, as was done in the case which I discussed in my brief. Then his testimony might be a little something different. If it depends on having uncertainty about the boundary for there to be an oral boundary agreement, well, then he becomes uncertain. And The appellant thinks it's very important for the court to take note of the way his testimony changed from the time we took his deposition and asked him where his boundary was, and he drew a diagram of it. And then after we went through the third-party practice and the motion to bring him in, and it became clear that uncertainty was a requirement for this oral boundary agreement to be given effect, I think then he became uncertain about that boundary, and that's the way he testified at trial. And I addressed those questions in my reply brief. And with that and my main brief, we asked the court to reverse the trial court's decision that this oral agreement was valid and either remand the case for determination of the boundary or to find that the preponderance of the evidence which we adduced, the natural markers, the common source deed, was enough for this court to determine the boundary. Thank you.
Thank you, Mr. Farmer, Ms. Miller, and Mr. Cowan for your arguments, and we will take the matter under advisement. Mr. Hibner.
This honorable court is now in recess until 2 p.m.